Mr. Cooper.
Good morning, Mr. Chair and members.
So you have item number 17, AB 2245. Please proceed.
Yes, Chair and members, AB 2245 will allow probation departments to purchase, train, and carry handguns with the same capabilities as their law enforcement counterparts. Historically, probation departments have been able to purchase handguns with the same features as police and sheriff's departments. Recently, some firearm retailers have excluded selling to probation departments these types of firearms because they are not explicitly identified as eligible purchasers. Probation officers train and serve alongside police officers and sheriff deputies on task forces carrying out the same duties. From my personal experiences on task forces, I can tell you that it is imperative for every task force member to have the same type of function of firearms capability on the range and in the general course of their duties. I respectfully ask for your aye vote.
Good morning, Mr. Chair and members. Danielle Sanchez on behalf of the Chief Probation Officers here as a sponsor. I want to thank Assemblymember Cooper for carrying this for us. Historically, probation has been able to purchase firearms that are not on the rostered handgun list under the Attorney General's office. More recently, a few probation departments, Marin and San Mateo, have been denied department purchases to upgrade their necessary on-duty firearms. As the Assembly member said, we train quarterly and work with other law enforcement agencies on task forces, and it's imperative that we are able to both train and purchase and use firearms that are similar to many other peace officers in this state. For those reasons, we ask for your support today. Thank you.
Mr.
Chair, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC. We're in support of this bill and another bond bill that expands the same to other groups other than probation, in addition to probation. Thank you.
Thank you. Other witnesses in support?
Mr. Chair and members, Matthew Seiberling on behalf of the Los Angeles Probation Officers Union, Local 685, and the Riverside Sheriff's Association, both in support. Thank you.
Mr. Chair, John Lovell on behalf of the Los Angeles County Professional Peace Officers Association, in support.
Thank you.
Good morning, Usha Machler on behalf of the California Probation, Parole, and Correctional Association in support.
Thank you. So witnesses in opposition, and if you could just move over to allow for space. You could stay at the table, but if you could move over one to allow them to get to the microphone. Two witnesses, 2 minutes each.
Good morning, Mr. Chairman, members of the committee. Ari Freilich on behalf of the Law Center to Prevent Gun Violence, respectfully urging you to oppose this bill. We believe this well-intentioned legislation would undermine California's law prohibiting the sale of unsafe handguns. 17 years ago, this legislature enacted the Unsafe Handgun Act to fill a major gap in federal consumer protection law. The act requires all new handgun models to meet basic reliability and safety standards, such as passing a drop test to ensure the firearm does not fire when it's accidentally dropped, in order to be certified for sale or manufacture by DOJ. This law has proven highly effective. According to CDC data, the rate of accidental shootings in California has fallen by more than 50% in the last 17 years, and is now just 1/3 the national average. The law exempts specified law enforcement agencies under limited circumstances and allows those agencies to purchase uncertified handguns for use in the discharge of official duties. It allows sworn members of these agencies and only these agencies to purchase these uncertified handguns for that purpose. However, the law does not require gun sellers to seek any verification that officers purchasing off-roster handguns were actually authorized to do so by their employing agency, does not prevent officers from keeping unsafe handguns in their homes. And because the UHA also exempts handguns sold in private or secondary sales, officers who obtain unsafe handguns could also subsequently resell them on the private market. This problematic exception should be narrowed, not expanded. This bill's proponents have pointed out that some non-exempt employees have been able to acquire off-roster handguns after some gun sellers mistakenly failed to differentiate between those eligible and non-eligible. However, instead of addressing this gap in enforcement and providing a workable pathway to compliance, I'm afraid this bill seeks to permanently codify a mistake. With great respect for the sponsor's service and experience in law enforcement, I question the wisdom and necessity of permanently authorizing these employees, all probation department employees, to purchase, carry, and keep in their homes handguns that could not pass basic firearm safety tests and that do not utilize a common sense safety mechanism to prevent accidental firings. We respectfully urge a no vote.
Amanda Wilcox, again on behalf of the 27 chapters of the Brady campaign. My predecessors with the California chapters worked very hard to get the initial Unsafe Handgun Act passed in 1999, as well as the additions to the act in the last decade. And many, of course, have personal experience in terms of losing a loved one to what were so-called junk guns and to guns without chamber load indicators and magazine disconnects. And as was indicated, there's definitely a public safety value to the requirement that a gun only on roster guns be sold. I had a very good conversation with staff from Assemblymember Cooper's office. I will not presume to know or want to tell law enforcement what guns they should be using while they are in active duty in dangerous situations, on a task force, on a SWAT team, or whatever. I won't do that. My concern is how this bill increases the proliferation of unsafe handguns and violates the intent of that initial law by enabling these guns to get into the civilian market through the private party transfer. I also am concerned that probation employees who never carry a gun in the line of their work are able to buy these guns, take them home, put their family members at risk, or sell them into the civilian market. So that is my concern about this bill, not what law enforcement themselves use when they're in active duty in dangerous situations. But I'd like to see the bill narrowed. At this point, we are therefore in opposition to the bill.
Others in opposition? Yes. Anyone else? No. All right. In that case, comments from members, questions? Mr. Cooper, you may close.
Thank you, Mr. Chair. I want to thank the speakers for their time and their comments. I disagree with them. The bill is intended to have law enforcement trained, and the bottom line, whether you're probation or sheriff's deputy or police officer, you go through the same firearms training. I worked on many, many task forces that are across the state, statewide, where you have probation officers on these task forces. They carry firearms. They work side by side with law enforcement, and in shootings, they've been involved in shootings together. And it's good, an integral part to know how each other's firearms work. If you pick it up, especially in these days, a lot of folks, the same guns work the same way. So if you're involved in a shootout, you can take your partner's magazine and use his. So it's consistent. These folks carry guns now. They are very safely trained. And I'll be honest with you, probation shoots more than some sheriff's departments do. As far as they qualify quarterly, a lot of departments qualify just twice a year. In Sacramento County, sheriff's deputies just shoot twice a year. Probation qualifies quarterly. So it's something that's much needed out there, and quite often they're facing folks that have bigger and greater guns than they do, a lot more firepower. This is just very simple. I have these same type of guns in my house right now. I've used them on duty, and what's ironic is even the agencies, so probation department is trying to upgrade their firearms, which agencies do. Firearms do wear out. And they're trying to buy new firearms for agency-wide, and they're prevented from doing that. So it really is an issue. Guns don't last forever. Eventually, every department replaces their firearms. So here's a probation department, 2 in the Bay Area, trying to upgrade their weapons and trade the old ones in. They can't do that. It's a department-wide issue. It's a public safety issue. So I would respectfully ask for your support.
Okay. So thank you. Could I have a motion? All right. First of all, I will be supporting the bill. The chair supports the bill and urges an aye vote. I have tremendous respect for Amanda and Nick Wilcox and the Brady campaign. I do think, however, as been stated by the author, that probation officers receive the same post-certified training, and in addition, they qualify quarterly for firearms training, which meets and exceeds the general training requirements. So I think we have a good case here that these people are qualified for these firearms. And again, with the chair, I urge an aye vote. The motion is do pass. Madam Secretary, please call the roll.
AB 2245, Jones Sawyer. Melendez. Lackey. Lackey, aye. Lopez. Lopez, aye. Lowe. Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago. Santiago, aye.
The measure passes. Thank you very much, Mr. Cooper.
Thank you, Mr. Chair and members.
I am going, unless the chair says otherwise, I'm going to run this through the 1 o'clock break, and if the sergeants can make sure that our other, I'm going to run it through the caucus time at least till 12:30 or so. So if the sergeants can make sure our other authors that might be waiting can come, or is it just Mr. Linder that's left? Mr. Lackey and Mr. Linder, we'll hear your bills then. Oh, and Wagner. Well, if he shows, give him a call and ask him to come. Okay, fine. Mr. Linder. So, let's see. This is, what's the item 14, AB 2088. Mr. Linder, please proceed.
Thank you, Mr. Chair and members of the committee. There's no question that hit and runs are a problem. They're on the rise, with the California Highway Patrol citing an increase from 73,000 in 2014 to 79,000 in 2015. If these numbers aren't convincing enough, all you have to do is turn on the nightly news, and there's bound to be a breaking story about another hit and run accident. This is a problem that impacts every one of our districts, and it leaves families torn apart and heartbroken. Take, for example, a horrible tragedy that just occurred right outside of my district. A first-grade little girl named Diasha Butts was walking home from school when a red Chevy pickup truck rammed into her. Realizing he had hit her, the driver sped away, leaving Diasha lying in the street, her pelvis fractured, legs fractured, brain bleeding, and lungs bruised. Diasha spent her 7th birthday in a hospital bed, awaiting a future of reconstructive surgeries and extensive rehabilitation. The driver was discovered a few days after the incident, his future to be decided by a judge. Under California's current penalty structure, he could possibly get off with a couple $100 fine, and that's it. I come to you today on my tireless quest to bring hit-and-run drivers to justice. Assembly Bill 2088 is a bipartisan solution that addresses the problems identified with last year's bill. The bill applies specifically to hit-and-run drivers who injure an individual but enter into a plea bargain agreement where the sentence is reduced to a hit-and-run with property damage. Under current law, the driver can settle in court having only to pay a couple $100 fine. AB 2088 corrects this injustice by requiring the immediate 6-month license suspension or court-ordered community service for defendants in these case scenarios. And the committee analysis raises two concerns which I would like to address. The first is that the bill limits judicial discretion. Given the fact that hit and runs have reached epidemic proportions, AB 2088 strikes just the right balance between granting judicial discretion and accomplishing deterrence. It ensures that hit-and-run drivers are penalized while granting the judge the final say in what the penalty will entail. The judge can decide whether to suspend the defendant's license or require community service. If community service is more appropriate given the facts of the case, the judge has the discretion for the amount of hours required. And the second concern is that the bill violates the Supreme Court's ruling in Apprendi versus New Jersey. And in my opinion, it was very clear that by accepting a plea bargain, one is already surrendering their right to a jury. However, if it's necessary, if the committee decides that it's necessary, I am open to amendments to make that position more clear, that the prosecutor's statement comes before the defendant agrees on record to give up his right to a trial. I would like to close by reminding committee members that California is home to the hit-and-run capital of the nation. We can do better. I believe that AB 2088 puts us on the right track by ensuring that hit-and-run drivers are held accountable by the suffering they cause. With me, I have Don Kepke from Crime Victims United of California and Nick Harris from American Motorcycle Association for testimony.
Good afternoon, committee members. My name is Nicholas Harris. I'm the Western States representative for the American Motorcyclist Association, and we are fully in support of Assembly Bill 2088. AMA is the premier advocate for motorcycling and the motorcycling lifestyle, and our members are concerned with any bill like this that may affect their enjoyment of motorcycles. In this case, we're very much in support. We support AB 2088 because it recognizes the proliferation of hit-and-run incidents currently plaguing the streets of California, and it provides a necessary, workable, and effective penalty to help address the problems and limit the number of unsafe drivers on our roads. The AMA supported this bill last year, and we're here again urging your support of this common-sense approach to remove a loophole in existing law and combat the epidemic of hit-and-run drivers. I strongly request an aye vote. Thank you.
Thank you, Mr. Chair and members. Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United of California, also in strong support. As was noted, hit and runs are a growing problem in California, which are leaving innocent victims lying in their perpetrators' wake. We, as CVUC, support stronger accountability for those who knowingly hit, injure a victim, and flee the scene, leaving those injured victims behind, hoping that their perpetrator will even be identified and found. CVC believes it's unconscionable that penalties allow for such perpetrators to escape any measure of accountability to their victims, and really believe that the current system as it relates to this particular class of offenders could even serve as a perverse incentive to flee the scene of a crime. AB 2088 is the least we can do to provide a measure of accountability, greater safety, as well as some semblance of justice to ensure accountability for the victims. So for these reasons, we're very strongly supportive of this bill. Thank you.
Any witnesses in support? Name and organization.
John Lovell, Association for Los Angeles Deputy Sheriffs, LA Police Protective League, and Riverside Sheriffs Association, all in support.
Thank you. Any other witness in support? Any witnesses in opposition?
Oops. Good afternoon, Mr. Chair and members. Khalif Asagai on behalf of the California Public Defenders Association. We agree that hit-and-run driving is a major problem in the state of California, but we do not believe that this is the appropriate solution to address this issue. Unless there's a serious question of fact, DAs are not in the business of regularly reducing the crime charged and offering plea bargains for a lesser offense. There is going to be an actual question of fact here, an actual question as to whether or not somebody was injured in these situations. So we don't see this being something that's being abused. When you lose your driver's license, especially for indigent defendants, which we represent, it really impacts your ability to get to your job, live your life in a normal fashion. In many instances here, where we're talking about property damage, if somebody was not actually injured, then this is an extreme penalty for those individuals who are involved. Additionally, courts already have the ability to impose both sanctions here, the community service and the 6 months, the 6 months of community service or the driver's license suspension. And so at this point, we're tying the hands of the courts who already have the discretion and also seeking to override the discretion of the DAs who are engaging in the negotiations to offer these plea bargains, generally, again, based on the fact that they are not likely able to prove the injury to another person in these situations. So this is a bill with good intentions, but it falls short of the mark in being appropriate, effective, or being able to truly reduce the instances of hit and run in California.
Natasha Minsker on behalf of the ACLU of California. Unfortunately, we are opposed. We think the approach proposed here is not consistent with the U.S. Constitution as interpreted in the Apprendi decision. I do appreciate the author's attempt to try and find a solution to that problem, but it's not a question of the order in which the information is given. Prosecutors are not actual witnesses. Prosecutors are not able to provide factual statements that are the basis for a sentence. The Apprendi decision says that in order to impose a sentence, a fact must be found by a juror, by a jury, or must be stipulated to. And the procedures proposed here do not meet those requirements. So we urge you to vote no. Thank you.
Are there any other witnesses in opposition? So it's moved and seconded. Are there any questions from committee members? No? Okay. So let's, Mr.
Wait, I have a comment. I think that the point by the ACLU is well taken, that we need to have juries decide. In addition, there can be some pretty minor property damage, which I believe under your bill would cause someone to have their license suspended, and I just don't think that's appropriate. Thank you.
Okay.
Thank you. For one moment, this bill only applies to those that have plead down from a case with injury down to one with property damage. So in this case, the hit and runs that occur where there's only property damage, there would be no change in the law. The judge already has the discretion to have a 6-month mandatory, a 6-month license suspension. So in the case of property damage alone, this bill would not change anything. This is only simply the case where you have a driver that has caused injury and that has been pled down to the lower tier where it would be the property damage only. And in that case, in relation to the comment that was made regarding having the ability to get to work, that was something that we didn't take into consideration the last time that I had tried this, and we took into consideration this time by allowing the judge to mandate some sort of community service, and that's at his entire discretion. So if the facts of the case were to be where it was minimal, he could reduce the hours of community service to a very, very minimum, and I think that still be true to the intent of this bill. As you're aware, and I think you can base it on my persistence of the hit and run legislation. This is something I'm very, very passionate about, and something that I think is very important to all of us in our communities. So I respectfully ask for an aye vote.
Okay. And so the chair was a no. I'm going to go ahead and do a non-recommendation, and I'm going to unfortunately vote no, and for many of the reasons that the opposition had stated. But I think it's good for members to vote their conscience and to decide which way they want to go. So
thank you.
It's non-recommendation, and unfortunately, I know this is really important to you. Okay.
AB 2088, the motion is due pass to appropriations. Jones Sawyer?
No.
Jones Sawyer, no. Melendez? Lackey? Lackey, aye. Lopez? Lopez, aye. Lowe? Lowe, aye. Quirk?
No.
Quirk, no. Santiago? Santiago, aye.
That measure passes. Congratulations.
Thank you.
Mr. Wagner, I know you're up next, but we both got to, I'm going to call a recess, and we'll come back. Is yours back? You have a.
Back to the district today. When do we come back?
Yeah. Go ahead. Let's hear it.
Thank you all, and I appreciate the indulgence. Hopefully, this will go quickly. We are with Assembly Bill 2008, and in a show of massive bipartisanship, I am urging on this legislature the exact same position that the Attorney General Harris urged on the court. So trying to do here the work of the Attorney General was done in litigation. This deals with the sex offender registration notice requirements. And the problem, quite simply, is this. Anytime somebody does 30 or more days in jail and they are previously adjudicated to be a sex offender requiring registration, when released from that 30 days, they are currently required to be told of the notice requirement that they've already been told of. The Attorney General has argued in the case of People versus Tolley that this creates and I will quote, an unnecessary, superfluous, and potentially confusing set of circumstances. Inmates are released at various times of the day. Staff in the sheriff's offices that are releasing them are sometimes just skeleton staffs. Some have more, some have less knowledge of the various requirements. And critically, this renotice requirement applies regardless of the underlying offense for which the prisoner has been held and is now being released. Therefore, if you're releasing towards the end of an evening with a skeleton shift somebody who is required, because of a prior conviction, to register, but is being held maybe now for, say, a shoplifting you still have the requirement as the sheriff's office to notify them of that pre-existing obligation, and failure to do so creates a loophole. This is an effort to close the loophole. The court rejected the Attorney General's argument, essentially said if the legislature wants to clarify and fix, the legislature can clarify and fix. AB 2008 clarifies and fixes. Makes it clear that the renotice requirement only applies if the incarceration is for an offense that requires notification in the first place, not if it's a completely different, superfluous, a different type of offense. The notice that the individual has already been given and is required to follow stays with them. And we close that loophole with this bill. And so I urge and I vote, and we'll answer any questions.
Corey?
Good afternoon, Mr. Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association. We're in support of this bill. As Mr. Wagner said, this kind of addresses an anomalous situation. This language used to be in the statute. It's not really clear how it got changed. There was a lot of alterations to the code with SB 1128 back in 2006. There's some concern that this language may have been a clerical error, but nevertheless, this bill does address a real problem, which, as Mr. as Mr. Wagner said, the statute now technically requires every person who has a duty to register under Penal Code Section 290 to be notified of that duty every time they're released, regardless of whether or not the offense for which they're being released actually is a sex offense. The person who is a 290 registrant has been notified by the court upon their conviction for their 290. They've been notified again when they've been released from custody the first time. So in essence, every time a jail sees this person again, they are giving at least the third notification of the duty to register, which exists for lifetime, and it exists regardless of that notice. And so, as Mr. Wagner said, the Toloi court declined to side with the Attorney General, but it made clear that this would be, because of the wording of the statute was clear, this creates a burden on law enforcement every time we release someone. It creates a problem, too, with the Attorney General's office, because then they get multiple notifications about a person. They may not always be in line with each other, and so you have a situation where you have a lot of deadwood or erroneous information in the sex offender registry, which is problematic because it is so large as it is. And so we think that addressing the bill, or addressing this problem with this bill, will address a lot of those issues. So thank you very much.
Okay. Any witnesses in support? Witnesses in opposition?
Good afternoon. Natasha Minsker with the ACLU of California. Unfortunately, we are opposed to this bill. We believe the legislature made the correct decision in 2007 when you created this notice requirement. Under California's sex offender registry law, a person who is in custody for any reason, upon leaving custody after 30 days, must re-register. This is true even if the person is returning to the exact same residence, even if the registration on file with law enforcement is accurate and less than a year old, even if the person is wearing a GPS tracking device, and in fact law enforcement knows where they are all the time. Even if all of those things are true, you are still required under California's law to re-register because you have spent 30 days in custody for any reason. And the failure to do so is a felony that can lead to a state prison sentence up to and including lifetime imprisonment under the Three Strikes Law. Under these circumstances, we think the legislature made the correct choice to ask law enforcement to simply tell people when they leave custody that they have this requirement to re-register. The court that reviewed this issue said that this is not a superfluous notice requirement because it's not obvious to the average person that you have to re-register after 30 days in custody, even if your address is the same, and even if you registered within a year. And so the Supreme Court, or the Court of Appeals rather, said it's actually quite logical that the legislature imposed this notice requirement. If we believe that this information is important, if we believe it's important for someone to re-register after 30 days in custody, and important enough that failure to do so is a felony that can lead to lifetime imprisonment, then it's not asking too much to have law enforcement take a few seconds to tell them that they have to do this as they're leaving. And if we think that burden of simply saying to someone as you're leaving custody, you have to re-register, if we think that is too much for law enforcement, then this shouldn't be a felony that you can go to prison for life. And so given the current state of California law, we urge you to vote no. Thank you.
Lee Foster, California Public Defenders Association. I'll just associate my comments with those of my colleague. We're also in strong opposition.
Second.
I had to step out. I'm sorry.
Which way are you going?
We're in support of the bill. Association for LA Deputy Sheriffs, Riverside Sheriffs, and LA Police Protective League, and LA County Professional Peace Officers.
Thank you.
Surely that didn't surprise you.
I had to ask. Are there any questions from committee?
Again, Mr. Wagner, you know I have deep respect for you. However, for reasons stated by the ACLU, it's critical that these people re-register, even if it's to the same address, even if everything's already on the up and up. Now, I think that's probably wrong law, but that's the way it is. The other thing to stress here is that the court has ruled that while it's the duty of law enforcement to say this, it's directory, not mandatory. Therefore, someone who doesn't re-register, even if they haven't been warned, is still subject to a felony. So I just, I'm sorry the sheriffs want to have more convenience not to do this, but I really would ask them to make their best effort. And if they fail, there's no penalty to them, and there's a huge penalty to this person. So I think it is up to them to please make the maximum effort. And again, we're not putting a penalty on them for not making it, and the person still has to re-register whether they've been warned or not, and they can still have a felony. So I think this bill is just not correct. I would love to change it so that they don't have to re-register after being in jail for an unrelated crime for 30 days. I think it's crazy, but that's not what the bill that's up here today. Thank you.
Thank you.
You may close.
Thank you. Let me maybe address that, although I don't know that I'll get you all the way there, Mr. Quirk. But realize this is not just a case of, well, you've got to simply tell someone, and this is obvious to it's not, and as the court said, not obvious to the average person. It's exactly the opposite. You're dealing here with a special class of defendants. You're dealing with somebody who has been told, and as Mr. Cizillos has told at least twice, about this duty to register. And so, we're not dealing here with the average person. We're dealing with somebody who recognizes their status is different, their status is far from average, and that they are under these heightened obligations, which they've been told multiple times. What we don't want to do is create a loophole. It is true that in the Toloi case, they said it's directory, not mandatory. But there's no guarantee that the next court is going to come to that same conclusion. And what we're trying to do is write into the law what the Attorney General has said ought be the law. She's our chief law enforcement officer, and maybe on many things she and I don't see eye to eye. On this one, certainly we do. We're writing into the law the clarification that is necessary to deal with this specific class of people. And I worry that there will be a loophole. And the case, and the Attorney General worried about a loophole, and the case didn't open it, but that doesn't mean it's not there. The potential is indeed there. So let me close by saying this is not a case of telling people. The issue is reminding them again and again and again. At some point, folks need to take responsibility. They've been told at least twice. The law is clear, and there is no reason to add to this additional administrative burden that at some point, some court somewhere might use to allow someone to escape from what is indeed a just punishment that the system has imposed on them. So with that, I urge an aye vote.
Okay. And thank you. I'm going to lay off on this one, and I'll just let you know why. We need to tell people as many times as possible if they have to re-register, to just kind of have this feeling that it's their responsibility. It's quite good, but we also have a responsibility as a court, as a police agency. I remember having a bill last year where I wanted the judges to go ahead and inform someone before they plea bargained all the ramifications that would come about, and the judges said it was too much for them to do it. It was a lot of work. But then they would find out they couldn't register for the Army. They couldn't get financial aid. There was a myriad of things that they weren't told about, but they pled out anyway, and they found out that their life was much worse than if probably they had fought the conviction. I think everybody should have all the information that they need, so that they can do the right thing, and so that's why I'm just going to lay off there.
Thank you, sir.
AB 2008, the motion is due pass to appropriations. Jones Sawyer not voting. Melendez, Lackey, aye. Lopez, no. Lowe not voting. Quirk,
No.
no. Santiago not voting.
That measure fails. Sorry. Mr. Lackey, that's the last one. It's just,
Second.
Mr. Lackey, the bill has been moved and seconded. Are you almost finished with your?
Ask for an aye vote.
Are there any witnesses in support?
Randy Perry,
Name and
Aaron Reed and Associates on behalf of PORAC sponsors of the bill. Thank you.
Timothy Davis, Sacramento Police Officers Association, in favor of the bill.
John Lovell, California Narcotic Officers Association, in support.
How many people you represent? Oh, my God.
Brent Meyer, Vice President of Peace Officers Research Association of California.
Thank you.
Matt Cyberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, and the Riverside Sheriffs Association, all in support. Thank you.
Any witnesses in opposition? Seeing none. Madam Secretary.
AB 1927, the motion is due pass. Jones Sawyer, aye. Melendez, Lackey, aye. Lopez, aye. Lowe, aye. Quirk, aye. Santiago, aye.
Measures out. We're doing the on-calls right now.
Item number 7, AB 1959, Rodriguez, Lopez, aye. Santiago, aye.
That measure passes.
Item number 2, 1762, Campos, Lopez, aye. Lowe, aye. Santiago, aye.
That measure passes.
AB 2369, Patterson, Lopez, no. Lowe, no. Santiago. Item 23, AB 2369, Patterson, Santiago not voting. That measure fails.
That measure fails.
Item number 26, AB 2477, Patterson, Lowe, no. Santiago not vote, no. Santiago, no. That measure fails. Mr. Patterson has asked for reconsideration.
Yes. By unanimous consent.
Hold on, please. We have one more item on call. Item number 21, AB 2340, Gallagher, Jones Sawyer.
No.
Jones Sawyer, no. Melendez.
That measure fails. Now we're going to the ads. That.
Item 10, AB 2012 Bigelow, Melendez, Lopez, Lopez, I. Santiago, Santiago, I.
Melendez is here.
Oh, she did just arrive. I'm sorry, she just arrived.
You okay?
I'm sorry. Let me go back to item number 5 since you've missed it. Item number 5, AB 1927, Lackey. Melendez, I. Yeah, that was just you. You weren't here.
You can't vote twice.
AB 2012 Bigelow, Melendez, Melendez, I. AB 2027 Quirk, Lopez, Lopez, I. Santiago, Santiago, I. AB 2078 Kim, Lackey, Lackey, I. Lopez, Lopez, I. Santiago, Santiago, I. AB 2088 Linder, Melendez, Melendez, I. AB 2227 Lopez, Lopez, I. Santiago, Santiago, I. AB 2245 Cooper, Joan Sawyer,
Aye.
Joan Sawyer, I. Melendez, Melendez, I. AB 2262 Levine, Santiago, Santiago, I. AB 2327 Cooley, Lopez, Lopez, I. Santiago, Santiago, I. AB 2340 Gallagher, Melendez, Melendez, I. AB 2367 Cooley, Lopez, Lopez, I. Quirk,
Aye.
Quirk, I. AB 2524 Irwin, Melendez, Melendez, I. Hold on just a moment. 9? Yes. Item number 9, AB 2008 Melendez, Melendez, I.
Gallagher. Yeah. Quirk did it. I had to leave. I had to leave to do my bill. Are we good? Do we stand adjourned or?
She added on to Cooper. Stand adjourned, sir.
Meeting stands adjourned.